Office of the Attorney General and Legal Affairs.
Madam President, I thank you most sincerely for an opportunity to contribute to the bill which appears before this most honorable chamber today. Madam President, this bill, if I may respectfully say, it is not only decades late, but is what I would say is yugs late. And yug is a Hindi word for its eras late. And I will tell you why I make reference to this. Madam President, believe it or not, today we all looked on at the swearing in of the Honorable Senator Mr. Mohan, whom I congratulate on your appointment. And the Honorable Senator, Madam President, he swore on the Bhagavad Gita. And the Bhagavad Gita is one of the epic texts of Hinduism. And looking on at his swearing in, Madam President, I remembered how pertinent the Bhagavad Gita is to, believe it or not, the bill which we are actually debating here today, Madam President. Madam President, I recall my days in the Ganesh Temple in Santa Cruz when my Guruji, he would spend a lot of time educating the younger ones on the Ramayana, the Bhagavad Gita, the Mahabharata. And I have to make mention to the gist of what the Bhagavad Gita speaks to, Madam President, and you will understand the pertinence. The Bhagavad Gita is, in essence, it's a dialogue that took place between Arjuna and Lord Krishna on a battlefield of Kurukshetra. And it was a battle between two families, the Pandavas and the Kauravas, and it was a battle for honor. It was a battle to save one's lineage. Now, predating the Bhagavad Gita, Madam President, is also another religious text of Hinduism known as the Mahabharata. And the Mahabharata, Madam President, is what gave us the reason for that, the battle that took place in the Bhagavad Gita. And believe it or not, Madam President, the battle that took place in the Bhagavad Gita that was mentioned and spoke about in our Hindu text, the Mahabharata, was as a result of a game of dice. It was as a result of an unregulated game of dice. In that particular text, which I will not certainly go into, Madam President, in the Mahabharata, it spoke about the problems that a society can face with unregulated games of dice. An unregulated game, Madam President, flawed by cheating, flawed by trickery, flawed by fraud. And as a result of this, Madam President, as a result of this unregulated game of dice, and these stories are eras old, it spoke to the negative implication it had on societies, because the Mahabharata and both the Gita spoke of empires and dynasties falling flat on its face because of an unregulated game. Therefore, Madam President, how pertinent it is that we have come as a parliament, Madam President, to bring a law to regulate a system that definitely needs regulating. There is nothing called over-regulating, as referred to by Honorable Senator Wade Mark. So, Madam President, I just want to place on the record my full support for the Minister of Finance in this bill that we have brought today, a bill that I will continue to repeat to say it is not decades old, or it's not, it is actually eras late, Madam President. Madam President, in the course of my debate, there are certain pertinent points of law that I would want to address, law that, and certainly clear certain issues that were brought up by different members of this Honorable Senate during the course of their debate. And if I have some time, Madam President, certainly I would, the crux of my debate, I would attempt to focus on the AML CFT provisions as alluded to in clause 31, 38, and 51 of the bill. And of course, time permitting, I would also want to spend some time looking at Division 2 of the bill. Now, before I get to that, as I said before, there are certain points of law that I want to respectfully address. One point, the first point that I want to address is respectfully a point and a question actually that was asked by the Honorable Senator Timal. And I recall the Honorable Senator, Madam President, he asked, the Honorable Senator basically said, he asked, why was the constitution of the board lengthy? It was a convoluted journey to appoint the first board. The Honorable Senator was concerned that the chairman, the deputy chairman, and members of the board, their terms of appointment did not expire on the same day. Well, Mr. Vice President, respectfully in answering the Honorable Senator's concern, I have to turn to the issue of corporate governance and the law as it relates to that. Honorable Senator, respectfully, this is what we term in corporate governance in this aspect of law as a staggered board. And the law is very, very clear, Mr. Vice President, that a situation where certain classes of directors have different terms of appointment or periods and serve different terms, the law of corporate governance dictates that a staggered board prevents a company's hostile overtake and so on. But in the context of government, a staggered board, it serves in insulating, believe it or not, it insulates a board from political influence. So certainly by the creation of this staggered board arrangement relative to this commission, it is not that we are being arbitrary on the law. It's not that the law is convoluted. It is actually good law in this instance for us to have a staggered board arrangement. For example, Honorable Senator, if you give board members an appointment for a same term, then what that means is that everyone's term on the board, it actually ends at the same time. If that happens, you're talking about a lapse in setting up a new board and the appointment of new members. The predicament that we can face in a situation like that is that, of course, if you don't have a constituted board, nothing can happen until that board is properly constituted. This particular provision, I would have looked at the provision again. It is drafted in the terms of, and it says within the bill, not exceeding 4 years. And so for the chairman, and others may get 3 years, this is to make possible the issue of a quorum, so that you will always have a quorum that this board can continue to operate. So let's say the chairman of the board, his term expires, you can still have a deputy chairman who is in existence. So therefore the board is still constituted to the point that decisions can be made. So just to address your concerns and your questions concerning what the construct and the terms of appointment, you can rest assured that this is not convoluted. It is in no way it's not a convoluted or lengthy journey. There was a lot of thought, a lot of corporate governance thought that went into the creation of this clause. So I do hope that you will consider giving us the support that we need, because this is indeed actually very good law. Mr. Vice President, I want to now address certain points that were made by my colleagues on the opposition bench. I must say, well, it's not a surprise, but I'm disappointed that there is not more enthusiasm for the passage of this legislation. And respectfully, I submit, Mr. Vice President, standing in the way of this bill is both unpatriotic and it is definitely obstructionist. Let us not, I want to respectfully say, Mr. Vice President, let us not blind ourselves to the level of smartmanism, if I may borrow the Honorable Prime Minister's words, that exists and takes place in this country. And I respectfully believe it is always better for us as a government to have control so that we could screen out the bad and keep the good, rather than simply leaving this system and leaving this industry unregulated. Now, Mr. Vice President, if I may respectfully address some of the comments made by the Honorable Senator Mark. Now, Senator Mark, he asked what was the objective of the legislation. He said we administer a dose of poison. We are uncaring because we want to regulate an industry, and well, he made mention of over-regulating an industry. You know, if I may respectfully submit, we cannot and we must not develop a mentality that we must live for free in this country. We do not wish to shut down the gaming industry. That is but mere propaganda. Mr. Vice President, why I say we must live for free, the purpose, one of the major policies behind this piece of legislation is because we all understand and we are not oblivious to the fact of the $1 million industry that the gaming industry, and the millions of earnings that the gaming industry makes. And it is necessary that this industry becomes properly taxed and properly regulated so that the government and the country, the citizens of this country can benefit from. Now, I was a member, I was a practitioner, I practiced in private practice. And even though I was not employed for the state as a lawyer, as a citizen of this country, and this has not been, and I'm in no way say that I'm perfect, but just being a citizen of this country and understanding my responsibility as a law-abiding citizen of this country, even in private practice, which I'm sure like many of my colleagues in here, I ensured that I was tax compliant and I ensured that I paid taxes because we understand that it's our responsibility to do same. So by regulating this industry, I say to the Honorable Senator Mark, this is not our intention to stifle any sector of our society, but it's just that this is what our country requires. This is what is required of us as citizens of this country. Mr. Vice President, there was also a statement made by the Honorable Senator on the point that landlords would be affected. He said that landlords would also be affected and that they would have to access what we call a premise license. In response to this, Mr. Vice President, I want to draw the Honorable Senator's attention to Clause 40 of the bill. Now, Clause 40, Mr. Vice President, it attaches conditions of a premise license, and in the law that appears before us, one pertinent condition is that the landlord must place in a prominent place on the premises rules by which the licensed activity will be conducted, including rules prohibiting gambling by minors. So, Mr. Vice President, if we even look at international comparators, so for example, if we look at the UK, under the Gambling Act, it imposed similar and like conditions, license conditions and codes of practice. So therefore, when we, in this present law, in its present carnation, as it appears before this Honorable Senate, we are also in alignment with international comparators that we would have turned to in assisting us in drafting this piece of legislation. There is also, Mr. Vice President, a strict responsibility requirement set out for gambling establishments relative to the underage persons. So certainly I want to clear the record and I want to put on the record that what we are doing as a government here today is certainly not whimsical, and it certainly is in alignment with international comparators that we would have looked at in the drafting of this particular piece of legislation. Now, if I may respectfully turn to some points that was made by the Honorable Senator, whom again, it's a pleasure to have the Senator here with us today. Personally, I feel it's a breath of fresh air in the Senate. Senator Rambajan, she would have asked the question, and she spoke about the appointment of members of the Commission. She indicated, the Honorable Senator said that it's open to political manipulation because they are appointed by a minister, and she also went into detail about no requirement for the commissioners to declare their interests under oath. Now, most respectfully, I would say to the Honorable Senator that most respectfully, what I can say to the Honorable Senator, Mr. Vice President, if we turn, for example, to the Public Life Act, the Integrity in Public Life Act, right? Once you are in public life, declarations, Mr. Vice President, will have to be made so that the members of the Commission, even though they are not mentioned here, as long as they serve on that particular commission, Mr. Vice President, that is the act that will require them, Mr. Vice President, to make, as long as you sit on that commission, which is a state entity, this is where the Integrity in Public Life Act, that is what speaks to they having to declare, and the onus is upon these commissioners to make said declarations. We can also, if we turn, for example, to Section 21 of the Integrity in Public Life Act, Mr. Vice President, we will see that persons who fail to declare, as we know, who are in public life and they fail to file their declarations, it actually creates an offense for failure to do so, and worse yet, an offense. Let's say you have failed, you have improperly declared, or you have concealed relative information or declarations from the integrity. So in that particular section, Mr. Vice President, it speaks to once found guilty of an offense, the said person will be liable to conviction, and it goes on to speak, of course, a summary conviction to a fine of $250,000 and imprisonment for up until a term of 10 years. Now, in that, so this is really my response relative to the Honorable Senator's concerns about, I believe the Senator would have asked, who guarding the guard, right? And what we have in place is other pieces of legislation, of course, and there is an interoperability of laws, which we must remember. So while this particular legislation may not in detail spell out what is the responsibilities of all, and it does that because I can actually turn to Clause 12 that speaks to the right of the members, to Clause 12 of the bill that appears before us, that goes into detail about their responsibilities and the declarations that has to be made. But notwithstanding that, we have other existing laws that members who sit on this commission will be called to answer and will be called to declare their interest in, if they have an interest or so in the gaming industry. So to answer the Honorable Senators, this particular act is what we can use as, or what we can say, this is what will guard the guard. Now, even if you turn to Section 29 of the said act, which is the Integrity in Public Life Act, it speaks to the issue of conflicts of interest as well, in the sense that as soon as a conflict arises or same is discovered, and this is what it says, one shall immediately disclose same and disqualify himself from the decision-making process. So certainly, I believe that there are measures in place, if not only within the parameters of the law in its current incarnation, or the bill in its current incarnation, as it appears before this Honorable Senate. If we are to turn our minds to the Integrity in Public Life Act and so on, that will obviously, those are the other legal provisions that will ensure that members who sit in this commission, that there are checks and balances placed over them. I invite the Honorable Senator, you can also look at the schedule to this particular legislation, and the schedule spells out all of the persons whom that particular that act would capture. So this is in response to one of those that point made by the Honorable Senator. The Honorable Senator, in her contribution as well, also asked for clarity between the authorized versus the enforcement officers, but she really did answer her question, because I remember she asked the question, or she placed the question as to whether one served an administrative function and one was serving in the function of enforcement officers, like police officers, and that is correct, right? And I am sure both the Attorney General and the Minister of Finance, when we reach the committee stage, certainly I'm sure they would be willing to hear what recommendations you have made, and then of course they would take a decision as to relative to whether or not those would be accepted or not. The Honorable Senator also dealt with the issue of warrants, and all I would add to the Honorable Senator's contribution, and I'm sure the Honorable Senator is very much familiar with the case of AG versus Williams. But I need to put on the record, Mr. Vice President, it has been stated in this particular case, applying for a warrant to access premises, as we all know, is nothing new to legislation. But one of the dicta that came out of this case, which is very pertinent, is the purpose of the requirement of a warrant be issued by a judge is a layer of protection between the citizen and the state. The function of the judicial officer is to satisfy himself that the prescribed circumstances exist. This is a duty of high constitutional importance. And this case, of course, would have spoken to the issue of the warrants and what must be satisfied when a warrant is actually granted. Now, I do hear the senator's concern relative to a condition of a license. So we're telling a man, on one hand, a condition of this license is that you must give us access to your property, and then access to the premises. And then on the other hand, you're saying that if you deny us access, we can use the warrant. We can go and apply for a warrant. But the Honorable Senator, I'm sure in her practice as a criminal attorney and as a prosecutor, you would understand that applying for a warrant doesn't necessarily mean that you're going to be granted the said warrant. And this is where I believe the checks and balances and the whole the rights of the person whom premises we want to enter is being protected. Because once you appear before a judicial officer, you have to satisfy that judicial officer as to what is your reasons for making the said application. And it's not going to be an ad hoc application because, so of course, and as practitioners of the law, you understand what are some of the questions that the court will ask you. Because, of course, you would have to show what is your reasonable suspicion, what is the basis of that. And if and only when you're able to satisfy the court of same, then and only then we understand that that warrant will be granted. Now, why I'm also mentioning this is because we understand the rights and we recognize the rights of persons who run and operate these industries and own these operations. And certainly we are not going to advocate for any piece of legislation that is going to empower the police just to bang down a man's door and rolling into his operations. So, with respect to the issue of the warrants, I just want to put on the record that as a matter of fact, because I know the opposition has been speaking a lot about the constitutionality of the bill and all of that, this, believe it or not, is one of the major provisions by ensuring that if access has not been granted to the premises, that we can do so by the application of a warrant. This actually is what creates the balance in the law in ensuring that we are able to protect the constitutional rights of the person who would have been the owner or the operator of that particular establishment. So these, Mr. Vice President, I believe those are some of the points that I would have made note of that I wanted to address as points that were alluded to by those on the side opposite. As per the gist of my presentation, Mr. Vice President, as I indicated before, I would want to take the members of this Honorable Senate to clause 31, 38, and 51, Mr. Vice President, of the bill that appears before us. Now, these particular sections, Mr. Vice President, I want to place on the record that money laundering, as we all know, it extends far beyond drugs. Money laundering encompasses profit-motivated crime from banks, securities, trade and insurance, fraud to prostitution, extortion, arms smuggling, terrorism, and most importantly, illegal gambling, because it's one of the avenues that often we know that money can be laundered through. Now, Mr. Vice President, the current regulatory framework for gambling industry, as we all know, is outdated, and there is certainly a need for reform. Now, gambling establishments, Mr. Vice President, they are in fact supervised entities, that is listed businesses, which face risks of money laundering. And then we have ML financing of terrorism and FD, which we know is the proliferation financing. Now, this, however, Mr. Vice President, is not reflected in the law in its current incarnation. And this is why, Mr. Vice President, we all, in this particular bill that appears before this Honorable Senate, we seek to amend Schedule 2, Mr. Vice President, what we also did of course, in looking at the whole interoperability of law, we sought on a previous occasion, Mr. Vice President, we sought to amend Schedule 2 of the Proceeds of Crime Act by inserting in the Proceeds of Crime Act, gaming and betting and business. So again, this is I always hear the Attorney General speaks about the alignment of laws position, and we always speak to the interoperability of laws. We understand that sometimes for one piece of legislation to work, consequential amendments would have to be made in other pieces of legislation. So what I can say is that certainly when we would have amended Schedule 2 of the Proceeds of Crime Act, that would have been in anticipation, of course, of this bill being passed. So we ensure that we're able to capture this industry under that piece of legislation. And therefore, all of the laws in this country, as it would relate to money laundering, as it would relate to terrorist financing and all of that, would also apply. Now, Mr. Vice President, if we look, so for example, if we look at the bill before us, if we turn to Clause 33, which states, and Clause 33 of the bill which appears before us, it states, the Commission shall assess an applicant as fit and proper pursuant to the criteria set out in Schedule 2 prior to the granting of a license. What I would now like to do, Mr. Vice President, is, and of course to avoid tedious repetition, because I know the Honourable Minister of Finance went into some detail with the criteria fit and proper, I would also just like to briefly address that legal point for the record. Now, Mr. Vice President, I would like to explain the general public, the fit and proper criteria, right? Now, this criteria, fit and proper criteria, is a mechanism, as we know in law, which the Gambling Commission would use when a person applies for a license, and where for certain specific events, such as appointing a new member of the Commission, may occur. Now, in paragraph 1 of Schedule 2, Mr. Vice President, of the bill that appears before us in its current incarnation, it says, every person shall be considered fit and proper if that person is of good character, competent, honest, financially sound, reputable, reliable, and discharges and is likely to discharge his responsibility fairly. Now, Mr. Vice President, to this end, I want to place that this stems from the FATF recommendation 28. So again, the issue of fit and proper was not pulled out of a hat. As in drafting this particular law, Mr. Vice President, we would have used recommendation 28 as our guidance. Now, recommendation 28, this is the aspect, this is the FATF requirement, which requires that businesses be subject to, and if I may take from the actual recommendation, subject to regulatory measures on the basis of risk-sensitive approach through subjecting persons.
You end at 317.
Pardon?
You end at 317.
Thank you, Mr. Vice President. Business subject to regulatory measures on the basis of a risk-sensitive approach through subjecting persons in managerial functions to a fit and proper test in order to prevent criminals and their associates from holding managerial functions in business. So, of course, this again, we will not only be doing a great service to Trinidad and Tobago by ensuring that we are in compliance with recommendation 28, but what we would also be doing by incorporating the fit and proper test, we would be ensuring that we're able, as a parliament, to be able to regularize who are the persons that are granted license to run operations like this. And again, this goes back to us being able to put a handle on white collar crime and being able to ensure that the persons who are able to satisfy us that they're entitled to operate these establishments, they will be able to satisfy us where they're getting their funding from, and certainly that is going to have substantial benefits to our criminal justice system. Now, what I want to look, Mr. Vice President, I must also mention Clause 31 of the bill, which appears before us in its current incarnation. Now, this establishes the FIU to be the supervisory authority for AML, CFT, and PF supervision on gaming establishments. Now, the question is, what exactly does this mean? Mr. Vice President, a gambling establishment now will have an obligation of applying for registration with the FIUTT within 5 business days of obtaining its license to operate as a gaming and betting establishment. And again, this is where we look at the whole. Yeah, so Mr. Vice President, this again is a very significant introduction in this particular clause because again it will assist us in our attempt as a government to pilot legislation that is going to help us to put and handle and if not devoid our society completely of money laundering and terrorist financing, because persons now upon even being granted said license, you're now demanded to register within a stipulated time frame with FIUTT. So therefore now FIU can flag you and you will be under their radars and we can monitor your establishment, we can monitor the money that is coming, the money that you're banking, all of those things, which of course I would want to believe that Trinidad and Tobago would be most happy about. So to that end, Mr. Vice President, I want to thank you very much for the opportunity to contribute, and I want to speak to Trinidad and Tobago and just to reinforce to the members of the public that this is a government that is working for you, and this is yet the PNM's attempt and this government's attempt to serve all manner of people in Trinidad and Tobago. I thank you, Mr. Vice President.